Okay.
Okay, this is the group meeting for Group 6, Business 275. And we are going to be going through chapters 2 and 3, right?
I believe that's what we're supposed to do, yeah.
Okay, so the template I have up here, it says, name those who participated in this group's meeting. So that would be Ben Wiggins and James. What's your last name, James?
Busboom, B-U-S-B-O-O-M.
Okay, James Busboom. Okay, and we'll have to put the link in after we're done with the recording. Now we're supposed to come up with an example all together. So from what I understand, we each come with an individual example, right?
Oh, I thought we were supposed to do each an individual example that kind of modeled everybody else's.
Okay, so we all come with our individual ones, and then we come up with one together based on that.
Okay.
According to the template, it says explanation of our example, but then we all came with one prepared, correct?
Yeah, that's kind of what I was thinking.
Okay. So, also, do you have any questions that you read in chapter 2 or chapter 3?
Not yet.
Okay.
Still trying to process everything, but yeah.
I'm trying to get through the writing in this. I do not consider myself to be ignorant, but I have a pretty high vocabulary, but some of the words in this book make me feel pretty ignorant. Ignoramus fool, because I can't understand half the legal proceedings going on here. Yeah. But I was having a question about, let me find it here, chapter 2. What is a statute, and why are there so many different names for things? Like, what makes a statute a statute?
I think wasn't it a statute because it was legislated that way?
Okay. So it's just a term for something that is legislated, right?
That's the way I understood it.
Okay. And I understand the separation of state and federal and how the courts are separate, but in terms of the Constitution, they work together and one is under the other and all that. I understand the Bill of Rights. Let's see. Understand the checks and balances. Okay, I guess maybe that is what I needed to know.
Yeah. I'm just pulling it up here on Wikipedia to make sure. Yeah. A written law passed by a legislative body.
There's just so many terms for the similar thing. It's an ordinance if it's local. It's a statute if it's by a body, but they're all rules, and then they uses all of them differently in the book, and that's why I'm just.
Yeah, it goes back and forth too much in the book sometimes, I think.
Okay, so update your study guide as needed, which is fine. I'll get to that later. Share your individual group preparation assignment that was submitted prior to your meeting. Okay, can you share yours first?
Sure. I did an example, kind of like what my wife works for a children's jewelry manufacturer distributor. Anyway, I kind of based it off of that, but put it into this. But they had Mama had a client or a customer, and they paid part of the bill, but then paid the rest and wouldn't go through and pay the rest owed, so they filed a complaint. When the summons came to Uncle John, he got his lawyer and they filed a, what was it called, an answer? Yeah, they submitted an answer because they didn't agree with all the claims. Then they went through the discovery period, gathering information. Pre-trial came, they met with the judge, and then they went to trial. And through the course of the trial, the judgment came in favor of Mom's Jewelry, and Uncle John didn't like that, so he filed an appeal because he didn't feel that he had to pay for anything over the cost of the original order. He didn't want to pay all the back charges, interest, lost wages, all that fun stuff. That's kind of how I managed to come up with 100 and something words on something like that. Because I didn't know how, I couldn't get it condensed like they had it in the example.
Yeah, they're like minimum of 25 words. I'm already at 200. I don't know.
Yeah. And I think that example they shared in the case, whatever, is like 30, 35. It's like, no, I can't get it that small.
Yeah. I was basing mine off of the video that we looked at, which was the Three Little Pigs one.
Okay.
And so I did it. It was Rabbit is suing Tigger for compensation of damages. Rabbit submits a complaint to the court of the 100-acre wood. The complaint states that Rabbit was allowing Tigger to bounce on his land, but that his garden was off limits. Tigger proceeded to bounce all over Rabbit's garden, wrecking his vegetables. Rabbit demands that Tigger pays him 1,000 acorns in restitution. So the summons was delivered to Tigger. Tigger sends an answer to the court stating he did indeed bounce all over Rabbit's garden, but did no time did Rabbit explain to him that the garden was off limits to his bouncing. The court found in favor of Tigger, and Rabbit was upset with this because they did not allow the sign he had posted that said no bouncing into evidence, and so he filed an appeal for that.
Nice. I love Winnie the Pooh.
And then I didn't know where we were supposed to stop. Like, was it through the appeal process? Because I did say that Tigger's lawyer is claiming that the sign should not have been in evidence because it was illegible, since they're both.
Yeah. I wasn't sure on where to stop too. I stopped got up to the appeal and left it at that. I didn't go through all the appeal process. But, after looking at all the other cases that they had on there, ours was the most open-ended.
Yeah, it was. Let's see. All right. Ask questions to clarify. I don't think there's anything that's needed there. Decided that the example aligns with the topic. Yep. Discuss possible modifications. Okay, so on yours, what was the result again?
The judgment was for Mom's Jewelry, and they included all the lost interest that they could have had on the full amount being paid on a timely manner.
Mm-hmm.
And Uncle John didn't think that was fair. He was only willing to pay up to the original order amount.
Okay.
I did a 80-20 split on what he paid.
So what was his appeal for then?
Because he was appealing that he didn't want to pay all the added fees that they included in there above the original amount that he was supposed to pay.
Okay. I thought I'm probably wrong because I'm very behind in this, but I thought that appeals could only be for the way that the judge the way that the judge handled it, not for the way that He was just upset with the result.
Oh, maybe.
I'm looking here.
Tell you what, these e-book things are nice, but it's trying to find where you need to be.
Yeah. Okay. Okay, so it says each party to a lawsuit generally is entitled to one appeal. Consideration of further appeals is discretionary, often denied. Do not hold trials. The court simply reviews the record of the trial and the brief submitted. Attorneys present arguments. It doesn't say when you can appeal. So, what allows an appeal in the book. But I thought that the videos that we had watched earlier had discussed it. But I could be wrong. At this point, I'm probably wrong. Okay.
I don't know. That's the thing. The stuff we watch in one, and the book is it's like two different halves to the same when they're. It's a half of a lemon and a half of an orange.
No, it really is. Okay. Select the best example from your group to include in the template. So we just pick one. That's what it says to do. That makes more sense. Okay.
I say we go with yours because I didn't type mine on a Word document. I just typed it onto the quiz. I didn't.
That sounds good. I'll just copy and paste it over then.
Yeah. I wonder if we can ask about that on the appeal. Like, what are the
grounds for an appeal? Yeah.
Yeah. I mean, because just how upset do you have to be, or is it something wrong in the findings or the evidence submitted, or what? I wonder.
I'm going to just Google search it real quick here. Okay. An appeal court can only set aside your conviction for one of the following three reasons, according to this site. The verdict was unreasonable, i.e. not supported by the evidence that was presented. The judgment made an error of the law, or there was a miscarriage of justice on any grounds. Well, that's vague.
Yeah, miscarriage of justice. Well, I don't think this is just. That can be just about anything.
Yeah. So essentially you can say the evidence is wrong, or the judge based his decision on a law that is wrong. He was wrong. It was wrong the way it was done. Or there's errors. Miscarriage of justice is pretty much both.
Okay.
Example being a jury member is biased, or the judge refused to provide an interpreter to an accused person who doesn't understand English. So I don't think it's unhappy with the result because, well, the book didn't cover this that I know of. Isn't arbitration or the result, isn't that in a separate case? Like, maybe I'm wrong. Never mind.
Let's see, arbitration. Unlike a mediator, an arbitrator has the power to make a final binding decision. Arbitration is usually shorter, cheaper version of litigation.
Yeah.
So it says both sides present evidence and arguments, although often in a more informal manner than court trials.
Okay. So, how are we going to write a quiz question based on this? Because that's the next step. We need to make a question for the quiz. And if we want to do it based on the appeal, then we need to understand it ourselves.
Yeah. Ah.
Let's see.
Yeah. Arbitration is under the section out of court procedures for settling disputes.
Okay.
So maybe arbitration doesn't even come into our scenario at all.
Yeah, I was wrong. I'm thinking about just the judgment itself. I thought maybe this is only in certain cases, but I thought that, the first case would be to find whether you're guilty or not. And then there was another court that you had based to figure out what your sentence or whatever it was, your judgment. But maybe that's only in criminal cases. Okay. I'm getting back to the section on the appeal. Okay. Okay, so right before it says the appeal, in that paragraph it says, either attorney can request that the trial court grant a new trial, usually for one or more of the following reasons. One is erroneous interpretations of the substantive law. 2, erroneous admission or exclusion of evidence. 3, insufficient evidence and or verdict contrary to law. 4, excessive or inadequate damages awarded. So you are correct. Your example is right. He's pleading that the damages awarded is too much, that he's only supposed to pay what he owes them.
Okay.
5, jury misconduct or other irregularities. And 6, new evidence comes in. Often these grounds, 1 through 4, serve as a basis for an appeal. So we could do it.
I don't know. Maybe mine's a little on the fringe of the appeal. Because I scrolled ahead right above the section out of court procedures, they have that things to remember spot. And the second to last paragraph, an appeal does not entail a new trial. The appellate court must consider the law as a whole. Its function is to furnish future guidance, not simply resolve an individual dispute.
Mm-hmm.
So that clears it up. You got to figure it out because it's not making much. It says one, then says a different thing.
Yeah. Well, appeal can be for requesting reversal or a new trial, I guess. Sometimes appeal might just be to throw it out of court. Then it shouldn't.
Okay, yeah, I see that there. All right.
Okay. Okay, let's see here. Erroneous interpretations of substantial law. I'm going to look at their example question that they had up, because I'm not sure exactly how they want us to word it here. Okay. Here's an example question. So by taking the example you have and thinking of a question, you could ask, here is, so come up with some questions and then decide which of the questions best help the student understand the concept. All right, so let's just go through it. With the example of Rabbit and Tigger, the questions we can ask is, we could do simple stuff. Who is the plaintiff and who is the defendant? That's a simple one, but it doesn't really touch on the appeal. We could say, what caused Rabbit's lawyer to submit an appeal? Oh no, but that's based on, I guess, what could cause Rabbit's lawyer to submit an appeal. Because then we can list things off, 3 of them that are wrong and 1 that is correct.
Well, didn't it say either side could file an appeal?
Yes, that's true.
Maybe we ought to put something like that in there. Like,
okay.
Can Rabbit file an appeal? Like,
Can,
I don't know how to word it though, but something to like. At the end of the trial, an appeal was filed. Who has the right to file an appeal? Does Rabbit, Piglet, or do both?
File an appeal. That's a good one. Okay. What other questions could we have? Gosh, this question thing is hard. I think it's funny. This is a 275 class, and it's like 4 times as hard as my 490 class.
Nice. Were you? I can't remember who posted. I think it was you saying that you've got a group meeting in each class you're in.
Yes.
I clicked on one of my classes, and apparently I'm in 3 groups on one class. Don't know how I worked into that.
I'm in 2 different groups in B380 as well. One is for studying, and one is for something else, apparently. So I don't know how it's going to work.
I tell you, I thought this would be a semester where I could get some stuff done, and like, man, between this and work, they're trying to kill me.
Okay. So when we create the exam question, do we put in our example and then put the question in? Or do we just kind of word it so it's more vague and can be anything?
Oh, that I don't know. Maybe we do our example and then put the question at the end, and then if that's wrong,
okay.
Because that way it's at least separated and no one has to go looking for it.
Right. So, who is the plaintiff and who is the defendant? The answers are simple in that. Rabbit is the plaintiff and Tigger is the defendant. Other answers we could give is obviously the backwards one. Tigger is the plaintiff and Rabbit is the defendant. We could say that the court is the plaintiff and Tigger is the defendant, and the court is the plaintiff and Rabbit. Oh, no, wait. The Rabbit is the plaintiff. And the court is the defendant. Okay. What could cause Rabbit's lawyer to submit an appeal? Well, the correct answer is shoot, this is hard. We're saying that the evidence was erroneously excluded.
Yeah, so that'd be like number one, erroneous interpretation of substantive law.
No, substantive law would be like a judge saying you have the right to deny someone that's black to eat in your restaurant due to this law in 1967.
Oh, so I thought substantive was land.
Uh,
Okay.
sorry, substantive is what?
Like land claims, like
Oh, I think it means that substantive means that it is already there as law. In this case, it would actually be number 2, erroneous admission or exclusion of evidence. Because based in the case, I said that the sign he posted, we're saying that that wasn't
oh, okay, right.
So in this case, it would be judge who did not allow his no trespassing sign into evidence. The opposite of that is we could say, what is the opposite of that? Because we're saying that, Rabbit wanted to add more evidence, but held it off since he felt it would not be needed for a verdict. What do you think of that?
I think that sounds good.
Okay.
Get enough right information and one couple changes the wrong words to make it the opposite.
Yeah.
Those always trick me up anyways.
And then we're saying that let me go back to the example. Then come up with just 2 others. Okay. All right. So we're going to say, what could cause Rabbit's lawyer to submit an appeal? Tigger's lawyer failed to do so. That one's a pretty simple one.
Maybe we should put he failed to do so within 30 days.
Okay. Good additional information that's not needed. I like it. And then we're going to say one more. What could cause Rabbit's lawyer to submit an appeal? Now, we can just do the Rabbit felt that that the jury was unjustified in their, what's the word, judgment?
Yeah. In the suspicion is
Verdict.
it's judgment, because verdict is what they come up with.
Yeah. Unjustified in the verdict due to because potentially you could say that the jury was unjustified in this case it wasn't because there's nothing there that says it would be, but if they were just like, we like Tigger better, then that would be unjustified. So we need to put something else in there that would make it not unjustified. We'll just say since Tigger won.
Yeah, that's good.
Okay, and then who has the right to file an appeal? We could say only the plaintiff, only the judge, only the defendant,
And then
the defendant, or the plaintiff. Okay.
so how many questions we have to come up with?
Just one. So now we have 3 questions. What do you think? Which one do you think we should go with? We'll just we'll do this.
I don't know. Maybe we should put all 3 in there and say, hey, we had such a large a broad
Topic. Yeah.
topic. We feel that there need to be more than one question.
It's true. Based on the example here, the question that's best focused on the topic I want students to understand. So in our example, we were kind of going towards an appeal, so we'll actually just take out this top one. Because that's not appeal, that's just court stuff. So we have 2 of them here. What helps them better understand the appeal process better? Probably the top one here. Huh? All right, we'll just submit this one. Make it simple on us. It was harder to come up with, so it'll be harder on the quiz, right?
Exactly. That's the way I see it.
Okay. So, write an exam based on questions should help. Must include at least 4 answer options. Provide a short description explaining why each option is correct or incorrect. All right, we'll do this. Have the template up. Margaret, where are you at?
How old are your kids?
2 and 3 months.
That's awesome.
Okay. Quiz question. I need to transfer that over. I put it in the wrong section. Oh. Let's see. Goes right here. Include the entire question, including the part of your example that should be included. Okay. I'll put that example part in too. And then the correct answer is, just have to, oops. How did I do that? Okay. Is Judge Pooh did not allow no trespassing sign into evidence. Okay. Correct answer, feedback. That'd be number 2, right?
That's the way I'm understanding it.
Okay. So, can we just put in what the textbook says here?
I think so. I don't think we can say it better.
Yeah. An appeal can be filed for no, not that's wrong way. Erroneous admission or exclusion of evidence. Okay. Wrong answer one is going to be Rabbit wanted more evidence. Rabbit had more evidence.
Yeah, that sounds better.
Yeah. And that can go on here. I'll fix all of that. Getting everything in the same format later. Seat needed for a verdict. Wrong answer feedback is, come on, Kendall, don't shut on me.
So where'd you get this format?
This template that I'm using
Yeah.
came in week 2 study group. In the instructions for the group leader, it has a little link here that you download.
Oh, okay. So you're the group leader this week.
I just figured I would be since I started the meeting. You can be it next week.
Okay. So I'm looking at this and like, now where did you come up with that? I thought I looked at everything. Wrong answer feedback.
Yeah, wrong answer feedback. So in this case, we're saying it's, new evidence, let's see, can't be brought forward after the fact.
Yeah. New evidence can't be brought after the trial.
So newly discovered evidence can be reason for an appeal, but evidence
withheld
known but withheld does not constitute reason for
That's
okay.
good.
Tigger's lawyer failed to do so within 30 days. This one's simple since Tigger's lawyer does not need to file an appeal since the court found in Tigger's favor. Well, actually, we can just say since. Yeah, all right. Or should we say since Tigger was happy with the result? No, we'll just go.
Yeah, I think it sounds good like that. The 30 days is just extra confusion for whoever.
Yep. I don't think there is a.
Yeah, I was looking. I didn't see a time limit on it.
Yeah. I'm gonna Google that real quick, just because. Not that we need to add it. Is there a time limit on appeals? It is actually 30 days.
Well, so let's leave it like that. Let's leave do it like that, and then.
You are a smart man, James.
Don't go that way. I got lucky.
Okay, wrong answer 3. Rabbit felt that the jury was unjustified in their verdict since Tigger won. And in this case, we're saying that unhappiness with the result does not constitute appeal unless it is due to mishandling of, not mishandling, um, misconduct
Yeah.
or irregularities within the trial itself. Okay. It's an hour long. Well, I guess we haven't been recording for an hour, but where is my paper? I'm going off. Okay. Choose a new group leader for next week. Well, we did that. James, you're in charge.
Thanks for your vote of confidence.
If you could, so I put the announcement on what we were supposed to do, just because I had to hunt to find it. I thought it'd be easy for people to do that.
Yeah, I saw that on there. I like that idea.
Could you do that next week since you'll be the group leader?
I can.
Okay. Just do that, the first day of the week or whatever. And then, well, we already confirmed next week's meeting time to be the same time, right? 7 o'clock?
Yeah, that works for me.
Okay, perfect. All right, so looks like I will finish putting my example into this paper that you're looking at. And
Okay.
then I'll submit the assignment, including the link of this recording we did.
Cool. Sounds
Now,
good. I might have to hit you up for some how to get the link set up and everything like that for next meeting, but that'd be about the only questions I have at this point that I know of.
okay. Have you used Zoom before?
Yeah, it fights me every step of the way. Like on the where you can record to the cloud or record to your computer, I don't have that option. It just gives me record to the computer. I haven't figured out how to do that.
Mine too.
Oh, okay. So that's not a big deal.
I usually just upload it to YouTube after that. Because
okay.
it automatically downloads to the computer for me.
Okay.
So I'm just making sure, I'm glancing at our assignments. Is there anything we need to do as a group? Group case presentation. With your group, you deliver a case presentation explaining the outcome for the case that week. Oh, so it's not every week we present, right? What? Yeah, okay. So we just need to figure out when our group meets and contact them about it so that we can do that in that meeting. I don't think we have to do it this time.
Okay.
Yeah, it just says read about it and prepare for it. It doesn't look like there's any this week. Okay. Good to know. And then we need to make okay. Sounds good. I think that ends our meeting. Thanks, James.
All right. Thank you, sir. Appreciate you getting it going for us.
Mm-hmm.
Have a good evening.
I'll see you later, and let me know if you have any questions.
I will do. Thank you, sir.